speaker is Mr. Metzger, Senior Product Counsel, Google Books. Very appropriate to hear you now.
Yes. Hi, I'm Oliver Metzger. I'm the Product Counsel for Google Books, which means that I approve the product features in Google Books. I've been at Google 2.5 years, so there's a lot of history with Google Books that I was not part of. And I actually don't work on the settlement, so please no questions about the settlement. And I'm sure there's people in the room who know more about it than I do. The title today includes the title, The Rise of eBooks and Digital Libraries. I was going to talk a little bit about digital libraries and some of the legal aspects, because that's what I work on. Because there's going to be digital libraries, but they're not going to be very popular unless they include recent materials. So that means that they're going to have to include copyrighted materials. From my perspective, I see several issues or themes that are getting in the way of full viewing the books in Google Books, and the law is actually sort of standing as a barrier to the public enjoyment of these books. The first of those is one that we're all familiar with, the problem of orphan works. Before I was at Google, I actually worked on this problem at the U.S. Copyright Office. I was in the Office of Policy and International Affairs for 4 years and was one of the lawyers who worked on the report on orphan works, and something sort of near and dear to my heart. This is a problem that exists for millions of books. Google Books in particular presents this issue very sharply because we have the books. We've even already scanned them, but we can't show them, and we keep them in snippet view because of copyright law. So it's a product where we could just essentially flip a switch and millions of books would be available, but the law prevents it. And this is also a situation where we're ready, willing, and able to pay, and we're happy to do that, pay a reasonable royalty for the use of these books. But since the owners of the copyrights in these books can't be found, we all are at a standstill. That's a problem that I think has now been recognized and is getting attention at the national level in Europe and in other places. There's no clear solution yet, but that's something that's definitely, I think, one of the things that is impeding the progress of digital libraries in general. The second topic that I wrestle with in my work is works that are not orphan works, but I'll call them conflicted works. That it's clear that, let's say, two people one of the two people has the right to the copyright in the work, let's say the publisher or the author, but as between them they're fighting. And neither one feels confident enough to give the license for the digital rights in the work. This situation arises when, let's say it's a novel from the 1970s, the contract that was originally written between the parties didn't contemplate eBooks, didn't contemplate digital rights, and the language they used was ambiguous. So now the two parties both think that they are entitled to the digital rights. And although each is not confident enough that they are willing to license it to others. So we're discovering a very large category of books. I mean, it's a problem that may be on the same order of magnitude as orphan works. So this is another thing where Google is ready, willing, and able to and happy to make these works available, but we can't because of the legal history behind these issues. Another area where there could be significant improvement. Another general issue for the progress of digital libraries like Google Books is the lack of a single clearinghouse for rights. Google has signed contracts with thousands of publishers to offer previews of our books, and now with the eBooks product, thousands of publishers are selling their books through us, and we think that's great. We have online sign-up forms, and so it literally thousands of publishers come into the program that way. However, it's still a lot of resources dedicated to a sales force to go out and do this. Smaller players don't have the resources to go out and sign up thousands of publishers. This is an area where if there was sort of one-stop shopping for these rights, that it would facilitate digital libraries across many other providers, not just Google. So it's another area where if you look at the legal landscape, it's basically a giant morass that the transaction cost could be brought down enormously by having some kind of clearinghouse. The fourth and final theme, my talk's going to be quite quick today, is just the general theme that mass digitization is good. This is something I probably don't have to convince this audience of, but we think mass digitization of cultural works is good for the public. We think it's good to preserve history, and that the policy decisions made around this should keep the mass scale in mind. So this issue sort of overlaps the other ones that I've just mentioned. So, for example, take orphan works. The proposal that I worked on at the U.S. Copyright Office was the proposal that the Copyright Office made to the U.S. Congress was one where you could use an orphan work if you could prove that you had made a reasonably diligent search for the owner and were unable to find the owner. But reasonably diligent search was not defined in a concrete way. So you'd have to have your lawyers say, well, given the state of the law, we think that you're good if you've done the following things. It would also be very sort of case specific. You would have to, for a book, maybe a reasonably diligent search would mean that you checked this database and you called these right holders and you did these 12 things. But in this particular book, it would also be important to check this other resource. So it would be a work-by-work analysis and very fact-specific. There would be no clearly defined criteria for what would constitute a reasonably diligent search. That may work for if you were trying to clear 15 books that you want to put in an anthology, but that system will not work if you want to clear 10 million books. So just the general theme of mass digitization, I think it's important to make sure that when we consider these problems of orphan works, conflicted works, rights clearinghouse, that each of those considerations is done with the theme of mass digitization in mind. So, for example, in the case of orphan works, if you had a crisp list of criteria that if you've checked this one database would be the best, but if you've checked these 5 databases, then your reasonably diligent search is done, and you don't need a lawyer to review each of your million searches that you did, or each of the million rights that you cleared. And the same could be said for the other areas of legal difficulty for libraries. So I think that's a very sort of narrow slice of the topic. The speakers before have spoken very broadly. For what I see in terms of the future of digital libraries, if we're going to have books from the most recent 100 years, there's going to have to be a lot of clearing out of the legal landscape along the 4 lines that I just mentioned. That was basically it. I'll be happy to answer the questions later. I know also, by the way, this topic sort of is a preview of some of the ones that are going to come tomorrow that my colleague Simon is going to talk about tomorrow. So anyway, thank you.